This is Alyssa Dowe's mock case project. Dogs. We love dogs. They have been man's best friend for ages. They are loyal, intelligent, and cute. Dogs are so amazing that as of March 15th, 2011, only dogs are recognized as service animals by the Americans with Disabilities Act. According to the Americans with Disabilities Act, Titles 2 and 3, entities must permit service animals to accompany people with disabilities in all areas where members of the public are allowed to go. This would include public schools. This brings me to the case of Albonia versus the School Board of Broward County, Florida. Monica Albonia is representing herself and her 6-year-old son, Anthony. Anthony suffers from multiple disabilities. He has cerebral palsy, spastic quadriparesis, a seizure disorder, he is nonverbal, and he is confined to a wheelchair. An individualized education plan was created when Anthony entered preschool. His disabilities were listed as intellectual disability, orthopedically impaired, and language impaired. Anthony's mom accepted the preschool IEP. However, Anthony's mom felt that her son required a seizure alert dog to protect him when he has seizures. So Anthony's mom purchased a service dog, and his name is Stevie. Stevie completed training in accordance with the Assistance Dog International Standards for Training and Behavior. Stevie was specifically trained to provide Anthony with assistance in the event of a seizure or medical emergency, regardless of the environment. In the event of emergency, Stevie has 3 functions. The first function is that Stevie will step up onto Anthony's wheelchair and lay across his lap, which keeps Anthony's head up to prevent choking. He will also help to calm Anthony by reducing outbursts and abnormal movements with just the weight of his body. He also will act as a tactile presence to arouse Anthony out of a seizure episode. 2 other functions include activating a sensor mat, which sends off an alert to human responders. He is also equipped with a special vest that includes medication and information needed for those human responders. It is noted that Stevie and Anthony are a service dog team, where Anthony is the target. If Anthony is separated from Stevie, then the animal-target bond is less effective, since the animal's ability to respond and perform tasks for his target is diminished. Over a long period of time, this can have a negative impact on the effectiveness of the service dog. Anthony's mother submitted the request for use of service animal in school district facilities form to the school board. She provided the school board also with a copy of Stevie's vaccinations. The school board ultimately denied her request. The school board responded via letter that she would need to purchase additional liability insurance for a professionally trained dog, and she would also need to acquire additional vaccinations that are beyond those required with the regulation of animals permitted in schools. Anthony began his attendance as a kindergarten student at Nob Hill Elementary School. The school board allowed him to bring Stevie under one condition. His mother would have to act as the handler for Stevie. She was handler from August 2013 to November 2013. She was not paid by the school board, and she did not assist school staff with any care for Anthony. In November, the school board made an administrative decision to provide an employee to be the handler for Stevie. The handler was the school's custodian, and his job was to walk Stevie alongside Anthony with a leash instead of allowing Stevie to be attached to Anthony's wheelchair via a tether, take Stevie outside to urinate, and to ensure that people do not approach, pet, or play with Stevie while he is working. Outside of school, Stevie is tethered to Anthony at all times, and he is trained to physically indicate when he needs to urinate. While at school, Stevie does not eat or drink, defecate, make stains, require cleaning, or exercise. The school board shares that they provide an exceptional student education teacher and 2 paraprofessionals in Anthony's class, and that they are able to provide the safety and treatment during Anthony's seizure. A 504 meeting was called, and the goal of the 504 meeting was to develop a healthcare plan which would go along with Anthony's IEP. However, both his 504 plan and his IEP do not list the use of a service dog while at school. Because of this, Anthony's mother chose to bring her case to court against the school board, being that they were making it very difficult for her son to have access to his service dog through the stringent vaccination requirements that go beyond the standard service dog procedure, the purchase of liability insurance, and the requirement of a handler. Discrimination claims under the Rehabilitation Act are governed by the same standards used in ADA cases. To establish a case of discrimination, an individual must show he has a disability, he is qualified, and he was subjected to unlawful discrimination as a result of his disability. The school board does not dispute that Anthony is a qualified individual with a disability. However, the court needs to determine if Anthony is being subjected to unlawful discrimination as a result of his disability. The court will analyze the facts of the case to evidence whether or not reasonable accommodation was provided. The exact reasonable accommodations that Anthony's mother requests includes the school board allowing Anthony to attend school accompanied by his service dog without having to provide a separate handler for the dog, waive paying the additional liability insurance, and forgo the additional vaccines. Anthony would be considered Stevie's handler. However, Anthony's mom requests that an accommodation be made for a staff member to accompany Anthony and Stevie outside when Stevie needs to urinate. The court states that the school board's requirement for liability insurance and excess vaccinations are considered a surcharge that amounts to an upfront fee for Anthony to attend school with his dog. The ADA states that businesses that require a deposit or fee to be paid by patrons with pets must waive that charge for service animals, since other patrons without a pet would not be charged. This applies to public education. Students without disabilities do not face these fees. Therefore, the court upruled that these requirements for insurance and vaccinations constitute an impermissible discriminatory practice. The court looked to the 2014 case of Sapel Palm Condominiums of Pine Island Ridge Association Incorporated versus Fisher for guidance. Fisher has multiple sclerosis, which causes her difficulty with grabbing and manipulating items. Her service dog is trained to help her by retrieving items, opening and closing doors, and turning light switches on and off. Fisher sought the accommodation to have her service dog accompany her in her condominium, even though the condominium has a no pets policy. The Fair Housing Act applied in her case because it states that discrimination occurs when there is a refusal to make reasonable accommodations in rules, policies, practices, or services, when such accommodations may be necessary to afford a disabled person an equal opportunity to use and enjoy a dwelling. The crucial part of this case is that the condominium argued, after being told that Fisher has a right to have her service animal in her dwelling, that Fisher did not need to have a dog that is over 20 pounds to act as her service dog, and would instead accept the use of a dog that is under 20 pounds. The court shared that persons with disabilities typically have the most accurate knowledge about the functional limitations posed by their disability, and an individual is not obliged to accept an alternate accommodation suggested by any entity. The School Board of Broward County, Florida argues that their trained staff can provide Anthony with the same seizure care measures provided by Stevie. This may be the case, however, it is not up to the preference of the school board to dictate the type of services a disabled person needs over that person's own decision regarding his own life and care, just like the condominium cannot tell Fisher the appropriate sized animal needed for her accommodation. With regards to providing reasonable accommodation, the court rationalizes the impact of separating Anthony from Stevie during the school day, which severs the human-animal bond. They look into the cases of Tamara v. El Camino Hospital, 2013, and Lentini versus California Center for the Arts, Escondido, 2004, which both highlight that separating a person with a disability and his service animal has irreparable harm, deprives the individual of independence, and is generally discriminatory under the ADA. The court then looks into the notion of Anthony being the handler for Stevie. The ADA states that a service animal shall be under the control of its handler. The court shares that requiring a public entity to act as handler for and to control the service animal would not be a reasonable accommodation under ADA. The school board argues that they cannot be required to provide a handler, that realistically Anthony cannot act as a handler due to the limitations of his disability. The court explains that if they were to permit Stevie to attend school with Anthony, that the plaintiff would need to provide a handler. But one of the issues of the law is that the language under the ADA is a bit gray. What classifies a handler with control over his service animal? The 2011 case of Shields versus Walt Disney Parks and Resorts determined that a service animal is under the control of its handler by simply ensuring that the animal is not left unattended. The ADA recognizes tethering as a form of control, which is a method that Anthony uses for Stevie outside of school. Allowing to have Stevie tethered during the school day would be a reasonable accommodation. The final issue is when Stevie needs to urinate. The ADA states that a public entity is not responsible for the care or supervision of a service animal. Another issue of the law that exists here is that the definition of care and supervision is under dispute. The school board argues that leading Stevie outside to urinate would constitute as care or supervision, which they cannot be required to provide. The court investigates the language further. ADA revised the regulation to include that walking or feeding the service animal when a person with a disability cannot may be satisfied by a family member, friend, or other person willing to take on this responsibility, which Anthony's mother did so previously. At the state level, Florida law states that the care or supervision of a service animal is the responsibility of the individual owner. A public accommodation is not required to provide care or food or a special location for the service animal or assistance with removing animal excrement. The Florida Department of Education states that the service animal is the personal property of the student, that the district school board does not assume responsibility for training, daily care, or health care of service animals. To further assist in the ruling of this case, the court analyzed the 2013 case of Tamara v. El Camino Hospital. Tamara, a 70-year-old woman who needs assistance with balance and walking since her back fusion surgery, requested that her service animal accompany her during her stay at the psychiatric ward within the El Camino Hospital. The hospital had to provide her with reasonable accommodation and permit her service animal to accompany her in a locked psychiatric ward, as well as allow her, with supervision, to care for the dog's hygiene needs by having a staff member accompany her when she takes the dog outside of the locked hospital area. Tamara's case is monumental to the case of Anthony and Stevie. The court points out that the school board is not being asked to provide a staff member to walk with Stevie, rather to help Anthony successfully take Stevie outside himself. Explicitly, the school board is being asked to accommodate Anthony, not accommodate care for Stevie. The court rationalizes that requiring the school board to monitor Anthony using his service animal is a reasonable accommodation considering the circumstances. It's not different than the same way a school would assist a non-disabled child to use the restroom, or assist a diabetic child with using her insulin pump, or assist a physically disabled child to employ her motorized wheelchair, or assist a visually disabled child to deploy her white cane. The accommodations are reasonable. The ruling states that the school board is required to allow Stevie to accompany Anthony via tether. The school board is required to provide a staff member to assist and accompany Anthony when Stevie needs to go outside to urinate. The school board may not request additional liability and vaccinations. This case will have lasting implications for the future conduct of school boards with regards to allowing students to use service animals. The school board attempted to place multiple financial obstacles in the way of Anthony's right to use his service animal. It is the hope that future individuals who require the use of service animals will know enough about their rights and not accept what a school board dictates regardless of their policies.